As a service provider, are you allowed to disclose to the person whose data has been requested that the data has been requested, or are you legally prohibited from doing so?
And that's our next question, so thank you very much.
So did everybody hear the question? As a service provider, do you have the right to turn around and tell your client that there is an investigation?
Usually in instances where there's an interest for the inquirer not to have the person subject to the inquiry made aware, that when they go to the court to obtain a warrant, they'll ask for an order prohibiting any disclosure of information pertaining to the warrant. So essentially, secrecy order addressed to the service provider, not to mention it. For a warrant having an interception of communication, it's understandable or comprehensible in the circumstances. And then depending on where they are in the inquiry or whether or not there's been an accusation made, then they will or not request an order for the party not to disclose any information pertaining to it. So it would, the answer would depend on the circumstance of whether or not there's such an order accompanying the warrant.
Yeah, it's quite similar in the UK, but in theory it is important, and certainly in practice, that you have the contractual right to disclose that. You state in the end user terms, so obviously there's a chain of people, but the term signed up by the end user acknowledges the fact that data may need to be handed over to the authorities, and also it may need to be transferred out of the European Economic Area. You do need consent for that. So that's really, if you've got that in place, you should be fine. Otherwise, you could be in a position where you have to comply with a warrant, but you could actually be technically in breach of, say, the Data Protection Act in the UK or its equivalent in the other member countries.
So in Switzerland, it's the same. We belong to the Group 29, that are the data commissioners of 29 countries and the European Community. And if you have read the last paper they published on cloud computing, you can see one conclusion that's really interesting. In this conclusion, it's written that you don't need to cooperate with authorities that are asking access to the data without being sure that they can ask it anymore. So I don't think the Group 29 will be followed by the European Community, because that means the rules will be more objectively, they will be more difficult to follow for the persons who are asking access to the data. But in Switzerland, if you have someone who is asking this access, it's not possible to speak about it. If someone is asking, perhaps the prosecutor with the Tribunal des Mesures de Contrainte, they will send something to the bank. But we are a little country, and in a bank, if they need to have access to something, there will be an employer who knows the customer, the final customer. And this is perhaps a little bank, and the people are speaking, they don't know, they are not able to speak about it, and they will take their phone and call the customer and say, I'm sorry, but someone has asked access to your data. Do you agree? So the mistakes are often, because you need to be really professional. If you are working for UBS or for Credit Suisse or for another company, Syngenta, perhaps you know the rules. But that's not, the person they are not able to understand all the consequences when they speak about something like this. And in different cases, we have learned what the prosecutor was doing before he has written to the people to say, I have been accessing to your data, I haven't found anything, or I have found something. So in theory, it's not possible to say to the people, but practically, it often appears that the people were aware of it without having been in the possession of information from the prosecutor.
I was reading the document from the Article 29 working party, and it says the disclosure of data to this party should be regulated via subcontract and should include an obligation for the provider to ensure access to information for the client about the changes in order to enable him to object to these changes and terminate the contract. Client should ensure that it cooperate with the client with regards to the client's right to monitor processing operation and so forth. So what the data protection Article 29 group says, if you receive a request, you're bound to tell your client. But again, it really depends on the kind of order, as Jean-François was saying, because in many orders, then it's required that the no disclosure of the access has to be granted. So it's really depends on that.
Yes, and to continue what Raphael told and said, in France we have to separate and to distinguish the criminal prosecution and investigations and the civil investigation, because in criminal investigations it's just impossible to disclose to your customer that you have received a warrant, for example, from a judge, because by doing that, by revealing the existence of this warrant, you should
Violating the law.
Yes, you violate the law, and because you are obliged to follow a principle that is the principle of the secrecy of investigation of criminal investigations. So by revealing the existence of the warrant, you can be prosecuted yourself on a criminal fundament. It's not the case in civil prosecutions, where you can contractually organize the communication of this information to your customer in order, for example, to have a contractual cooperation with your customer on how you reveal what kind of information you can disclose, etc., etc.
We are there with safety.